Good morning, ladies. Good morning. How are we doing today?
Good morning.
Good morning.
So, great. Outstanding. That's wonderful to hear. All right. So let's start just by checking in and making sure that you guys feel okay about last week's lecture and make sure that you have an opportunity to ask any questions that you might have. So what did you learn last week, and is there anything that still isn't clear about it?
I'm okay for now.
Okay. But there are two parts to this piece of the conversation, right? And one is me asking, do you have questions? And the other is me asking a question that needs an answer. So I understand that you don't have any questions. That's fine. My question still needs to be answered. So
What's the second question?
my question was, what did you learn last week in the lectures?
Okay.
And the reason that I ask this, right, is because I want to make sure that what I think I'm teaching you is what you are actually getting from the lectures. So that's the reason why I ask this. I'm not trying to play gotcha with you. I'm trying to make sure that I'm giving you what I think I'm giving you.
Right. So we kind of looked at remoteness and the doctrine of foreseeable harm, or it is. We looked at, I think you had asked, you said there were 3 questions that the courts use, which would be, hold on, let me tell you. You broke it down even further where you were like, is the source of danger reasonably foreseeable? Is this reasonable foreseeability, or is this a reasonably foreseeable way of being harmed? You have to ask yourself these questions, sorry, which you then also called like the Daphnis test. And then you also said, is it reasonably foreseeable?
Credit where credit is due. The Daphnis test is actually Ward's phrase, right, but I liked it. I liked it. So.
And then you also said is reasonable foreseeability, or is it reasonably foreseeable that the harm would be occurred or would have occurred, or that you would have been harmed? That sounds like a little garbled. Excuse me. And then you kind of broke it down even further to say that for those 3 questions, there's a way that the courts, there's a broader way to look at those damages that you have to then ask yourself, or that the courts ask themselves, which would be harm to the person or to your body, harm to your property, which can be your home, your car, and then also pure economic damages. So these are all damages to these 3 things. We then looked at, you also mentioned that within these 3 things, they have to match each other. So you can't have like, for example, if you have a damage in, you kind of said like, or not you said, because then you're like, well, did you get it? You said, so if it's a damage to like harm to the body, then you will get nothing if it falls under, say, harm to your property. Like they have to kind of come together.
If the foreseeable harm is harm to property, harm to the person is probably not recoverable.
Right.
Those 2 in particular overlap enough that I think it's I think you're probably okay on that prong of the inquiry for the if those are the 2 categories. The real issue is when you're trying to recover for pure economic loss, those are very difficult to prove because it's rare for a tort to cause a foreseeable economic loss, right? And so those are the cases where that bit of the remoteness analysis comes into play most commonly. There are exceptions. We talked about some of those exceptions, but it's far more likely that you're going to run into an issue with that piece of the analysis with an economic loss claim.
Right.
So, anything else?
We looked at, and anybody can jump in at any time.
Okay, you had made reference to, when we talk about reasonable foreseeability, and you had spoken about a doctor treating a patient and giving bad advice for their health, and you, if I remember correctly, you said that would be economic, that would be economic loss in.
So it was a specific case.
Right, the Stephen versus their Montgomery Hospital, if my memory is still correctly.
Yeah, and what happened was, on the basis of the doctor's negligent advice, the plaintiff had undervalued a personal injury claim that they had, and they had settled it for less than they should have. Okay, and so the claim was for the additional value that the personal injury settlement would have had the plaintiff not received the negligent advice. So it was a very sort of narrow kind of facts, but you're absolutely right that this was something that we talked about.
Okay.
Okay. Anything else, guys?
We also looked at the eggshell or egg skull plaintiff rule, where the defendant can't escape tort liability for the damages caused by the plaintiff being uniquely vulnerable. Then there was the scenario of the person, throwing the rock thinking nobody was around, but hits some person, which normally it would be fine. That person, might just get a scrape or a bruise, which, but if that person was uniquely vulnerable, which was the example used, this person had brittle bones, and so therefore, it caused the damage to the skull where in the end they died. Then I think, I could be wrong, if a person, you have to take the person as is. So you can't, your reasonable person, you can't kind of judge it based off of a reasonable person being like, you said, I think, Achilles or Hercules, but you have to use the person as is. So if that person has brittle bones or has some kind of issue, then you actually have to take the person that is presented. And then what I thought was interesting was that you kind of asked us about the superseding cause. Yeah, it was, I think, a little muffly, but not on your part or on Rudolph, I think, who gave the example. But just because I think I need to stew over a little more, I tend to need to stew over for a little while to gather. But I think it was because, but when you gave the example of the superseding cause, like how would that eggshell plaintiff rule work with the superseding cause? It was, you kind of said that you have to look at the sequence of events. So if the vulnerable person, if the vulnerability came after the injury, then it's not foreseeable. Like you can't look into the future to know that such and such, that what happened would have caused this person to then be vulnerable in the future. But if they were vulnerable beforehand, then you are liable, or then the defendant will be in trouble. Okay, cool.
Yep. This is all exactly right. Yeah, perfect. You got it completely. I don't feel like you need to stew anymore over the relationship between the egg skull plaintiff and the superseding cause. I feel like you've got it perfectly under control. But if you don't feel comfortable with it, then certainly your revisions are your choice. Okay. Anything else, or is that
Yeah,
it?
yeah, made reference to the Wagamon case. But I don't know exactly. If you can explain that again in respect to the reasonable foreseeability, can you
Yep.
go over that for me, please?
Sure. So think about the Wagon Mound case, right? The Wagon Mound case is this Rube Goldberg causation case. The ship discharges oil into the harbor, and then they are, sort of welding on their deck, doing some repairs. The sparks fly. The oil has not been carried away from them. It ignites and it destroys the wharf. And they are attempting to hold the ship owners responsible. Okay. And one of the things that I think is really helpful for us is to take these sort of convoluted facts and to work through the remoteness analysis that the courts take. So is the instrument of harm in Wagon Mound a reasonable source of danger, right? Well, that requires you to identify the instrument of harm. Is it the oil? Is it the hot metal? Is it the combination of the two in proximity? Like, how do we characterize it? And depending on how you characterize the instrument of harm, you may reach a different conclusion, right? So, for example, you know, hot sparks on a ship may not be seen as a reasonable source of danger because the ship is normally surrounded by water. And so, if hot sparks fly away from the ship, they just go into the water and they're doused, right? So it may be a situation where even on the first prong, the reasonable foreseeability isn't quite there, right? But if you characterize the instrument of harm as the oil, right? Oil is certainly a reasonable source of danger. We know that oil burns. We know that oil burns when it's in the presence of hot substances, right? It's very easy to ignite. So, if the oil is included in your calculus of the instrument of harm, maybe we proceed beyond the first step of the analysis. And certainly as students writing an exam, you should engage in all of the steps of the analysis, even if you were sitting as a judge, you would stop at the first prong. Okay, so that's just an exam tip, right? Even if you reach a conclusion that when delivering a judgment would cause you to stop the analysis, you should go ahead and finish and work through the whole process as a student writing an exam. So moving on to the second step in the analysis, right? Is there something bizarre about how this sequence of events comes into play, right? What we're calling the daftness test. And it's, I think that if you look at sort of the history of the Wagon Mound case more clearly, you might agree with me. I think that it is reasonable to sort of look at a harbor and go, the water doesn't move as much here as it does, out on the open ocean. Oil that's discharged from the ship is going to hang around for a while, right? It'll eventually get broken up and carried out, but the harbor is going to be kind of gross for a while. I think that's reasonable to foresee. And certainly, even though the court in the Wagon Mound case found that the sequence of events wasn't reasonably foreseeable, when they remanded for a new trial with proper instructions on foreseeability, the fact finder found for the plaintiffs again. So with proper instruction, the fact finder still found that it was reasonably foreseeable.
Okay.
So, and then sort of to finish this up before I go on to Elan's question in the chat, right? We go on to the type of damage, right? Certainly fire is a hazard to property. And so the damage to property is reasonably foreseeable. And so that doesn't require a whole lot of analysis there. Okay.
Okay.
All right. So Elan, you asked about the exam, and
well, I asked, sorry, I don't want it to seem random. You were just giving us some guidance before about the exam. So I said, well, let's piggyback on that one just to.
Yeah. So without sort of getting too far out in the weeds on this, because I do have something that I want to cover today for the tutorial activity. Assessments have been approved by the central administration, by ACWAC and BUS. So I will be discussing those on Wednesday. But sort of the broad strokes are, there's going to be a midterm exam. It's going to be next week. Then there will be a final, and that will be the assessments that we have in this class. The midterm will be multiple choice / short answer. So you're going to answer a multiple choice question, and then you're going to explain why your answer is right. And the purpose of that is so that even if you get the wrong answer on the multiple choice question, if you find some nuggets of useful information, you can get some partial credit. And then the final exam will be essay oriented, and you'll be given a problem. Embedded in that problem will be some questions that give rise to arguments related to policy, and you'll address the questions as it calls for. So that's about as much information as I have right now. I don't have a lot. I don't anticipate having a lot more information about the final for a while yet, but obviously tomorrow in the lecture there will be, tomorrow in the lecture there will be an opportunity to ask questions about the midterm. Okay. Okay. Any other questions or concerns before we move on to today's activity?
No, not as yet.
Okay. Then we're going to move on. And today's activity is about causation. And this, you may recognize this question. But it's to describe for a client how causation is established in cases of negligence. And so one of the things that's really important about this question is the phrase "for a client," because the simple fact is that clients are very rarely very sophisticated, right? Particularly if you're a plaintiff's lawyer doing, road accident work. A lot of times your clients are just very ordinary people who, if they're fortunate, have never had an encounter with the court system in their lives, right? If they're unfortunate, there may be some, traffic tickets or criminal charges running around, but the hope is that this is the only time that they've ever had to deal with the legal system. And so you can't do what a lot of law students like to do, which is to just sort of regurgitate the language of judgments back to the professor. If you are talking for a client, you have to speak in language that a non-lawyer will understand, which means that you have to take in what the courts have said in the judgments and figure out how to express it in terms that a non-lawyer will understand. Okay, so do you guys feel like you have had a chance to think about this question and to put something together, or do you want to take a few minutes to gather your thoughts?
I didn't get the question altogether. I just have described for client home causation. If you can put the question back up there again, please.
Sure, I'll put it in the chat for you again.
Thank you.
Describe for a client how causation is established in cases of negligence. So,
Thank you.
so are you asking for a few minutes to gather your thoughts?
Yes.
Okay, then we're going to take a few minutes. With so few of you, we're not going to put you guys into a breakout room, but I am going to turn off my video and mute, and also take off my headset so that if you guys sort of need to, but I will be here. So if you need anything, just pop in the chat and I'll be glad to help. Okay, so let me do that. Okay, guys, so we are back. We're back on the record. So as you guys know, I will call on folks if I have to, but I always want to give you guys a chance to volunteer first. So if anyone would like to volunteer to take a stab at how you would explain causation to a client, we're listening.
Can I try? Not sure.
Absolutely, go ahead. And let me just jump in and say, right, that this is a learning process. So there are certainly wrong answers, right? There are wrong ways to do this, but every effort is a step towards being correct. So go ahead, Rosalind.
Okay. In speaking to my client, I would inform them of the first and distinguishing if it's causation. If it's causation, I would let them know that there's 4 things that we need to consider. I will use the term elements as you spoke about the legal jargon, and they may not be able to relate to that. So I would say, well, there are 4 things that we need to look at. And what I have here in trying to establish if it's causation is a duty of care. If that person owed a duty of care to the plaintiff, and then I also said if they breach your duty, and also I look at the close proximity, if they were within close proximity, and if the causation was reasonably foreseeable. Sorry, my tongue gets twisted there. If the action or the cause of it was foreseeable, then the person might not be responsible. So first we'd have to establish these fundamental points that I just told you. That's the road I went down.
Good. Okay. So one thing that I would suggest is, like, legal jargon is okay, right? You shouldn't be afraid to use legal jargon if that's the most accurate way to describe what you want to describe. But you should make sure when you're talking to a client that you explain what it means. So for example, right, you talked about we have to figure out if there's a duty of care. Okay. Well, that's a legal term and it may be self-explanatory, but it may not. And so it might be helpful for you to say, so a duty of care is when the law has decided that because of what you are doing, what the defendant is doing, that they have to take precautions to prevent harming people. Okay. and what those precautions can be depends on the circumstances and depends on what they're, what activity they're engaged in. But the law has decided that we want to demand this of them. And the issue, right, and then you sort of move on to breach, and you're saying the issue is that they didn't take the proper precautions in how they treated you, right? So very well done, right? I would say that I think that some of your presentation is not about sort of narrowly about causation, but I think that's okay, because I think, one of the things that I've tried to emphasize for you guys is how tort law is not siloed, right? We don't have this sort of very clean discussion of the duty of care and then the breach and then causation, right? These things all sort of interweave among themselves. So while I think that, there is a way to sort of narrowly focus on the issue of causation, I think you're doing, I think it's really helpful that you're showing the client how all of these things are interrelated. Okay. And Kezron, please don't think that I was harassing you over technical issues. It was just funny that and this is not, you're not the only person that this happens to, right? You say, okay, it's time for you guys to present to the class, and then suddenly people start dropping out of the tutorial. So, and I always believe that it's a coincidence. I always believe it's technical issues, but it always strikes me as funny. So Rosalind, that was really great. I really appreciate you going first. I know going first is scary. So who would like to go next?
I'll go.
Okay.
Okay, so basically, causation addresses what resulted in the harm. This is determined based on two things. Firstly, we need to show that the defendant caused the harm due to their negligence. We're looking at the situation as a matter of fact. If the damage you suffered would not have happened if it wasn't for the negligent act of the defendant, if the damage you suffered would not have happened if the defendant wasn't negligent, then their actions were the cause. If multiple persons committed an act and it cannot be distinguished who caused the specific damage, they'll both be responsible. If you are caused further harm as a result of the initial harm, then they'll be responsible as well. However, if something happens between the defendant's act and the harm, if it is sufficient enough to cause the harm, then the chain of causation is broken. All this simply to say that there must not be such acts. So, if you can show that it is likely that the harm was a result of the defendant's act, then we can make a case.
Great. No, that's great. I think that's exactly right. I don't have anything to offer. Let me throw something at you as a curveball, right? How would you explain causation to a defense client? So this was very much a plaintiff-oriented presentation, and that's perfectly fine, because I told you guys to be worried about explaining to unsophisticated plaintiffs, right? But sometimes defendants are not very sophisticated too. When I was in practice, I did a lot of my defense work was representing a lot of small business owners who didn't necessarily understand the details and the ins and outs of the employment laws that I was representing them for. And so, it was important to be able to explain those laws in a way that made sense to them. So, I think this is a really effective explanation. I think it's plaintiff oriented. So how would you change it to talk to a defense client.
Okay, so if I was talking to a defendant, I modify certain aspects.
Mhm.
So I would say to look at instead, what we're going to look at what you did, and we're going to look at if that will essentially we're going to look exactly specific, and then we're going to see if there's a link between you and the harm that was caused to the defendant. And if we can find something to say that your action, then we would be able, there is no case. Also able to find some intervening act that could have the harm, we would be able to essentially in the case.
Great. No, this is that you broke up a little bit through, but I was able to follow the train of what you were saying. I got enough of it, so I don't need you to repeat anything. But I think that was exactly right. Right. Because the idea is you always want to be focused on advising your client. Right. You certainly would not talk to a defense client about you know how are we going to prove the claim, right? We'd be talking about these are the weaknesses that we're going to be looking for. So great job, great job. Elan, you can offer your thoughts if you want. I'm happy to help you craft your own wordsmithing if you want. But certainly certainly we don't have to continue to pursue the right answer. So this would just be to sort of give us another example of the language to think about. So,
Right. I'm between two minds, especially after hearing both of them. I'm like, okay, you definitely don't need mine. But I could try. It sounds a bit garbled, especially after hearing how clear and concise the others were. But I'll try. I mean, hopefully I'm even saying the right thing, but we'll try. So, to establish causation in cases of negligence, I said, the person who's bringing the case forward must prove that the person they are bringing the case against, that their actions were the actual cause of that injury. I said, in law, we call or look at it through the lens of a but-for test, which is just basically saying but for, or if not for that person's actions, your injuries would never really have happened. This is a way for the courts to just justify compensation because that person caused or contributed to the injury or negligence of the victim. Also, the doer must, and so then I broke it down to say, well, instead of saying defendant, I said, well, also the doer must have a legal obligation to the victim. And the legal obligation was the duty of care. So I said, also the doer must have a legal obligation to the victim. The doer must have breached that obligation. That doer must have caused a harm to occur, and that would have resulted in damages. And so I'm telling the person, you look at the but for, but then we also look at the foreseeability of the injury. And the foreseeability is just the ability to anticipate the potential results, such as a damage or injury that might happen if there's something negligent or if something breaches that contract. I said, if the doer's actions were the but-for cause of the injury, the doer wouldn't be liable for damages if she or he could have foreseen that they would have caused the injuries. Well, forget that part. That part is just making it a little more garbled. But yes, that was my contribution. Okay.
okay, so I agree with you that it is not quite as like simple as some of what Kezron and Rosalind said. But I think that there's some really helpful things in there. One is I think that you do a really good job of laying out how we prove the but for causation, right? So we're looking for what other things are out there that are causes of the injury, right? And if there aren't any, then we infer that the negligent act caused it, right? And sometimes this is very simple and straightforward, right? You know, you you get rear-ended in a car wreck, and you know, smash your head on the steering wheel. Well, the bruise or cut on your forehead is very clearly caused by the force of the collision. Sometimes this is very subtle and difficult, right? As in, you know, if you are a shipyard worker and, you know, 20 years after you retire, you have developed a specific form of lung cancer, right? Does anybody recognize the reference here? Are you guys familiar with this?
So are you referring to a case?
I'm referring to a lot of cases, actually. This is the asbestos litigation. So basically, there is a specific form of lung cancer that is so strongly associated with asbestos exposure that if you are diagnosed with it, your doctors start looking for asbestos exposure in your history. And the association is actually so strong that the litigation involving asbestos manufacturers has created a settlement with strict liability. For if you have these types of cancers, you are entitled to a payout from the settlement fund, because it is simply without having to prove that you actually were exposed to asbestos, because the connection is so strong. So you can also recover if you can prove that you were exposed to asbestos and you have some other form of health issues, but this one is but this specific type causation is assumed because of the
Okay.
medical evidence.
When you say you would have to prove that the asbestos caused the problem, would that be the like risk, the thing speak for itself?
Yes, it would be a form of res ipsa. Yeah.
Okay.
In that there's no necessity for proof of causation. Okay. So what other questions do you guys have before we wrap up?
Just one thing, sir.
Mhm.
I'm still trying to really distinguish the difference with regards to remoteness.
The difference with regards to remoteness and what?
Remoteness
Difference
and
implies
causation.
two. Okay, remoteness and causation. All right. So
Yes, sir.
if I don't see that as I think that's very common. Okay, so I don't want you to feel like there's something wrong with not understanding that, just as an initial point. Causation is ultimately about a question of looking backwards, right? So we're asking, can we draw a connection between the harm that the plaintiff suffered and the alleged negligent act, okay, or the proven negligent act, since by the time you get to causation, you've proven duty and breach, right? So causation is a backwards looking process. Remoteness is a forward looking process. So you sort of put yourself in the position of the defendant having completed the negligent act, and you ask, would a reasonable person in the defendant's position have gone, oh, hey, if I do this negligent thing, this harm will occur or could occur. Okay. So that I think maybe, does that help as a lens to think about it, that causation looks backwards and remoteness looks backwards from the harm, and remoteness looks forward from the negligent act.
Yes, sir. Yes, sir. That definitely makes it clearer.
Great. Okay. So what other questions do we have before we wrap up?
Can you just give a brief scenario as for the remoteness when you speak about the forward, and you can just give an example?
Right. So I think that the Paulsgraf facts are actually really helpful for this. And because of the difference between how Justice Cardozo approaches the issue versus how Justice Andrews and everyone in the Commonwealth addresses the issue. So I think this is really helpful, right? We have this, the negligent act is pulling the passenger onto the train, right? So the non-negligent railroad employee would have been like, sorry, catch the next one, right? But the guard is trying to pull the guy onto the train as it's leaving the station. And, you know, the remoteness analysis asks, pulling the guy onto the train, would you reasonably foresee that, you know, even if you knew that he was carrying a package of fireworks, okay? So assume that you have that piece of information. Would you expect that a woman down the platform would be injured by something falling off the wall onto her? And Justice Cardozo says, no, you would not see that, right? Justice Andrews says, absolutely, you would see that, right? You would foresee that coming because it's, you know, it's an obvious foreseeable, you know, the harm that is foreseeable is harm to persons, and here is a harm to persons, so it is foreseeable, right? So does that maybe make it a little more clear?
Yeah, I'm with you.
Yeah.
Oh.
So the causation analysis of this would be asking, okay, Mrs. Paulsgraf got hit by these scales falling off the wall of the station. The reason that the scales fell off the wall of the station was the shock wave from the explosion. The reason for the explosion was because of the guy getting negligently pulled onto the train. Okay, so that's the causation analysis looking backwards from the harm, and the remoteness analysis looking forward from the negligence. Okay?
Okay, very well
So.
explained.
Well, I appreciate you saying that. All right. We are out of time. So if there's anything else that is very fast, here is your chance. Okay, then we will wrap it up here, and I will see you guys tomorrow. So take care and bye.
Bye, sir.